again, but we'll go ahead and get started. Late afternoon on a Friday. You're still here. Thank you. Thank you for coming. I think the next guy has cartoons, so if you make it past mine and you stay in here, I think you get cartoons. There will be no cartoons in this lecture to speak of, but this is the ECA of the Information Technology and Information Security seminar. I'm going to talk mostly about legal developments and things that are at least quasi-legal in nature, and certainly we won't be getting into any heavy technical stuff. My name is Neil Riemann. I have a law firm here in Raleigh called Penry Riemann. We do a lot of business litigation of a wide variety of types, but I also provide advice on information privacy and security. Don't do that much actual breach litigation, which is what most law firms do or are interested in doing, because it involves a lot of hours and a lot of billings. I really have this practice as kind of an antidote to my litigation practice, and hope to do and try to do more counseling and advice. Before I start talking, I thought I always like, especially at a security conference as opposed to a legal conference, to find out like who came to see the lecture. So, first of all, how many clients do we have? How many lawyers are in here? Anybody? One. Okay. Anybody else? No. Wow, that's unusual. Usually there's 3 or 4. What about what about IT people who are not security focused? What about privacy people? Any privacy people? Okay, the lawyer. Anybody else? All right, a couple of people. And then everybody else, anybody not in information security that I haven't already, I've covered pretty much everything else. Okay, 1. What do you do? Sales. Sales, all right. No, 2 sales, okay. All right, well, so most people are actually domain specific. All right, so one of the questions I always get at these technical conferences, these information security conferences, there's always some kind of hard-boiled hacker who says, who cares? Who cares about the law? You're going to get hacked no matter what legal regime you adopt. So, why does it make any difference? So that's one of the things we'll talk about a little bit today. We'll also talk about actual developments in the cases around the country. We'll talk about changes in the statutory law, either the federal law. Actually, I'm not sure if we have federal law developments. I can't remember, or if we just have state ones. We'll also talk about actions by the executive branch, the president, all the agencies that do security and privacy-related enforcement. And finally, we'll talk about some international developments, and we'll talk about some what I'll call looming issues. Probably things that are going to come up after this lecture. So on this issue about who cares about the law and why, the argument usually goes, well, the law is not going to stop breaches, so why should I care? And I had this discussion with this fellow this one time, and I said, well, what do you do? He said, I'm a pen tester. I said, well, pen testing is not going to stop breaches either. Is it really? Well, no. Well, why do you do what you do? Well, so one of the answers is deterrence. We don't stop things, but with the law, if we set the regime up correctly, we can deter things. We can either deter them generally, or we can, by punishing specific people, deter those specific people from doing it again. We don't stop murders through the law either, but we do deter them from taking place. The law can also, legal developments in the law can also serve a kind of education function, especially to the extent that they actually require people to be trained and educated, which some of them do. And finally, the law can actually provide what prevention cannot, which is compensation for people who have been victimized. In terms of who actually cares about the law, right now Equifax cares about the law quite a bit, right? We'll talk about that more later, but what happened to Equifax for a company like Equifax is a potentially company terminating event. Russia cares about the law because the law is really an attack on critical infrastructure and the things that Russia has been accused of doing have attracted a lot of scrutiny to the activities of Russia and have potentially led to some will potentially lead and have potentially led to some pretty serious sanctions and scrutiny. Finally, our own government cares about the law. Not as much perhaps as it should, but some of the big issues this year and next year have to do with the scope of the government's own power under the law to conduct activities like surveillance, and we'll talk about that as well. The one thing the law will not do, however, is achieve justice by itself. This is a favorite quote of mine from a book called A Frolic of His Own, which is kind of a satire on the legal system, and the author has the character say, justice is what you get in the next world, in this one you get the law. So we are only approximating in the various terms justice. So one thing that the law determines that actually is very important in the cases is something called standing. Just because somebody has done something bad in the world of information security, just because there's been a data breach, does not mean that somebody can go to court and take action on it. The law requires anybody who goes to court in any kind of case to have something called standing. And the law also determines whether consumers and other people have an effective remedy of any kind. Now, it might not just be them going to court personally, but it might be some government entity going to court on their behalf. So, for example, there are laws authorizing the SEC, the FTC, the Office of Civil Rights in the healthcare arena, the Consumer Financial Protection Board, and state attorneys general to take action related to cybersecurity issues. The law also determines whether shareholders can sue. This is becoming kind of a hot area where, because of the security breach, the stock of the company drops. And there are fairly complex set of rules governing when shareholders can bring action against management, basically for insufficiently securing the data of the company, or people, really personal data held by the company, that led to this drop in stock value. Among bank cards and card brands and merchants, the law, really the law of contracts for the most part, but also there are probably some regulatory components, determines who can go after who in those situations and when. And of particular interest maybe in the security community, the law has really important ramifications for who can be prosecuted for whether security researchers and hackers can be prosecuted for doing what they do. This has to do with the definition of unauthorized access in the Computer Fraud and Abuse Act. We may have time to talk about that a little bit. So those are some of the things that the determines. It also determines, very importantly, whether there's some kind of insurable event, whether an insurance policy covers a company for a data breach, either for the cost of responding to the breach or for all the collateral damage that results. And whether companies like Equifax, of course, will continue to exist. Now, in terms of actual specific cases that arose in 2017, this is kind of a newsflash. This just happened a couple of days ago. Probably at least a year ago, maybe more, Microsoft sued the Department of Justice. They've sued them a number of times over a number of issues in the data security arena. But this particular one was a challenge to the government's kind of long-standing practice. Whenever they send over a subpoena or warrant to an entity like Microsoft for stored communications, they usually accompany that with this little letter that says, it's a gag order, that says, you're not allowed to tell the person whose record we're trying to get that we're trying to get those records. You're not allowed to do that ever. So not only not right away, but not ever. Well, Microsoft, especially in the current environment, recognizes that consumers are placing a pretty high value on the privacy of their stored communications, and so Microsoft challenged this ability of the government to bring these, to write these indefinite gag orders and get them, enforce them, and brought the case to court. The government tried unsuccessfully to get the case thrown out. The case was actually set to go to trial in the middle of next year. But the other day, Rod Rosenstein, the Deputy Attorney General, basically threw in the towel. He sent around a memo to all the U.S. attorneys that basically said, we're not going to do that anymore. We're not going to send those kind of orders. Now you need to tell people that we might withhold the information from the subject of the investigation for a finite period of time, especially for national security reasons and so forth. But it'll be an extremely rare case when we'll ever say we're not ever going to disclose that we sought these records. It's a little unclear if there was a quid pro quo, but Microsoft dropped the case almost immediately thereafter, so there's likely some negotiation discussion.
What does it mean for existing letters that were sent?
According to the memo, it doesn't mean anything. In other words, those orders that are indefinite will remain in effect. Although, one might speculate that there will be further actions related to the fact that they're being treated differently than people are going forward. Microsoft's not the only person who can bring this claim. Certainly nobody else agreed not to bring such a claim. The problem for the individual is they don't know, of course, that their records are being sought, so they never bring the claim, right? It would have to be some kind of big provider, Apple, Google, or Microsoft. So that's kind of an interesting development. This obviously is a huge development. It hasn't actually changed the law yet because it's too early, but I bet it will. 145 million records breach. There's only 323 million people in the United States, and almost all these records were of United States persons. So, and probably those are pretty much every adult because it's pretty much everybody who might have any kind of might use any kind of credit. You can speculate there might have been a few people they didn't get for some crazy reason or another, like they haven't applied for credit in the last 30 years or something. But otherwise, it looks like they pretty much got the whole shooting match. There's been several dozen cases filed already, I think. The breadth of their, how many of you have ever actually ordered your credit report and had it sent to you? We got a lot of security people in here. That's the way above average. Lawyers and security people order their credit reports more often than most people. They've got a lot of stuff, and a lot of the stuff that they have is exactly the stuff that people use to verify your identity when you phone in and say, certainly the stuff they use to verify your identity, right? If you call in Equifax and you ask to put a security freeze on or lift the security freeze, they say, well, what's your mortgage balance? Well, that's exactly the information they just gave everybody, right? So they've got kind of a big security model problem now in that they've given away all the information they heretofore have used to validate identity. One of the interesting things about it is a lot of the information they have is wrong, as you know, if you've ever ordered your report. So, for example, I used to have difficulty. I've had a security freeze for a long time on my account. I used to have trouble lifting it and unlifting it because Equifax had this persistent problem where they had my address listed as a prior address, and they would not change it. I corrected it, and then it would pop back. Somebody kept reporting my old address to them, and they'd change it back. And then when I try to authenticate to them the next year to do something, they'd say I didn't enter my own address correctly. So, that's going to be kind of one of the interesting features of it. Is I think it's going to show up exactly how much information they have. They really don't validate very well. These breaches not only affect companies like Equifax. So this is another one from just a few days ago, which is the only reason I pulled it. But it's kind of the opposite end of the spectrum. It's a small actor, but a fairly huge impact, right? This is a plastic surgery practice in London. It's called London Bridge Plastic Surgery or something like that. Yeah, plastic surgery and aesthetic clinic. So they claim to have terabytes of these people's plastic surgery info, and they claim to have all these famous people as clients. So you can imagine that's a fairly detrimental and terrible impact for those people. And there'll be a lot of, even though small actor, you can imagine a big case for suit coming out of it. Yeah.
You always hear about the Equifax case. It's almost like one of the great things where they were, they deserved it because whatever. But you don't hear about the rapists. We never. It's just the hackers. It's very generic. Why are they saying North Korea, was people's names, faces? They used to have bank robbers. They showed the face of the bank robber who robbed the bank. They didn't just say the bank was robbed and that was it.
Right. Well, you might know more. I can't remember what you said your particular bailiwick was, but you may know more about this than me. I mean, attribution, general attribution is maybe not so hard, right? There are actors from Russia. Specific attribution, like it's the Russian government as opposed to just somebody that they might give money to or might live in Russia that they tolerate, is a little harder to do. Pictures are harder to come by. Effective in catching them is harder, right? They do occasionally catch people, and they do make the news. I think they caught one or two this year, right? Were people roaming around over in Europe that were captured on Interpol warrants. This is a big company defense, right? We're a victim too, right? Feel sorry for us. Well, okay. I mean, lots of crimes have multiple victims with different, at different levels of specificity. Just because you're the victim doesn't mean you weren't also part of the problem, right? And so we're mostly not in the criminal law regime here. We're in the civil law regime. So we're not talking about putting people in jail. We're talking about monetary penalties, compensation for the people who were most injured. If Equifax could find the people who injured it, they could obviously get compensation if the people had enough compensation to give, which they won't. Victims doesn't necessarily mean they don't deserve compensation from Equifax. Because Equifax, I think it will become clear. I think it already is clear. They could have done better, right, for an entity that size and place. Standing, the question, the issue I mentioned to you before, is kind of this very convoluted doctrine that it's perceived to be very important in the law, because what it does is keeps every Joe off the street from running into court and using the courts to basically challenge legislation in which they really have no interest. If you don't have to have a personal stake in the dispute, then the theory is that litigation would kind of be even more prevalent than it already is, and people already think there's too much, right? So standing is a way to try to limit the universe of people who can bring lawsuits about particular laws. And a lot of the data breach cases have trouble getting out of the blocks because of this standing issue. And a lot of the litigation that goes on in courts is about this kind of preliminary matter. Now, the Supreme Court decided a case called Spokio last year. Spokio is one of these kind of second-tier information brokers. It's not a credit bureau like Equifax. It's kind of an overall information broker. It's used by employers and people who check backgrounds. And the question in Spokio was this fellow basically alleged that a statutory law had been violated, but the question was whether he actually suffered any harm and therefore had any standing to bring this claim. The Supreme Court basically takes the case and they say, well, maybe we're going to send it back to the lower court to think about this more because they didn't do it quite right. And more specifically, what they said is, in order to have standing, the plaintiff, I think his name was Robbins, had to have concrete injury. Concrete and particularized are buzzwords in this area of the law. Particularized means it's something that you can actually describe in a fairly discrete way. And concrete means it's not too intangible. So it's not like my feelings were hurt. That's not concrete. It has to be something more specific than that. And so when he went back down to the lower court to work on this case some more after the Supreme Court sent it back down there, he thought about, Mr. Robbins said, well, my injury is I was applying for a job at the time and I didn't get a job, and I think that this Spokio data, which was wrong, that was really why he had a claim under the Fair Credit Reporting Act. The Spokio data, which was wrong, might have caused me not to get a job. And so that's his injury, and that's what he, and then the Ninth Circuit, which the court they sent it back to, said that's good enough, that's a concrete injury. And as far as I know, that was in August. And as far as I know, there's not been a public record development about it. It might be that the case is going to be settled or has been. That's the last thing I know about it. One of the key questions in all these cases and all the courts across the land with respect to standing is, what if your claim is that because my data was taken, there's an increase in the risk of harm to me in the future? In other words, I can't say anything's happened to me yet, but I can darn well say that there's a lot more likely that something's going to happen to me. My ID is going to be taken. And so, is that enough to give me standing to sue? And the answer to that is that courts have come out in a different ways, but the trend seems to be toward permitting suit in those cases, which are still looked at in a kind of case-by-case way. On this question of risk of future harm, these are cases from 2017. So the D.C. Circuit said that there was a risk of future harm was good enough in that particular case. Atias, there's a case called Alaruso versus SuperValue. They also said that. Also true in the 6th, 7th, and 11th circuits. Yes, sir.
I was going to ask, is that risk of future harm, being able to prove that, going to be diluted with so many of these companies with massive data breaches? Like, no, that was probably from the other guys.
Well, so that I've never thought of that, and that's an excellent question because but of course, if you're the company making that defense, it kind of puts you in a really ugly situation. Right? It's not a happy thing to have. If that's your best defense, it's kind of an ugly thing to have to say. But I'm not saying it's not right? I mean, at some point they can only steal your social security number or your bank account number or your birthday so many times, right?
And which of the half dozen breach notifications do I go after?
Right, and so that could be. But my thought is really that, I mean, in the European regime, I don't think this matters really at all. Like they recognize kind of dignitary harms from having your personal information taken. And so I think after the Equifax breach, it really brings home kind of how I think it's going to bring home so what can happen to you in the future that's not immediately manifest. And I really think that the trend is probably going to keep going in this direction. But there are cases that say otherwise. There's a kind of separate question, though, which is the Spokio question, which is whether it's not about risk of future harm, but it's about whether Congress passes a law and says you shall not do something that hurts that to somebody, like report their credit information incorrectly. And then somebody goes and does that, and the Congress says if you do that and there's a lawsuit and there's a fine associated with that, then can you bring a suit for anything other than the fine that you're supposed to get? Can you bring a suit for some other kind of harm that the data breach caused you? Just because you can point to a federal statute and say, well, Congress meant for that not to happen, so I should be able to go after these people and get whatever damages I can show. But risk of future harm is worth, if some economist comes in there and says, I'm now more likely to be harmed in the future and that's worth $20, that's all I get, right? But if I have a class of 100,000 people and they each get $20, then that's a little different. Or a million people, $20 a pop, that's a little bit different, right? These are all class actions, so the recoveries are all these big sums of money. They're all settlements. They rarely go on to the end, which is why so many of these questions are still open. There's a third way, besides this argument about risk of future harm and statutory violation, that people try to get into court on these data breach cases. And there was development in this area as well. And that's a contractual theory. And that theory goes like this. It says, well, so I signed up with Scottrade to do my stock trades. And part of what I signed up for was the notion that Scottrade would not just willy-nilly give away my financial information, my personal information. I expected them to keep that confidential. And if I'm lucky, they even said in their terms, they were stupid enough to say something specific about it in their terms and conditions instead of just something really generic, like we might have security if you're lucky. So if they made a specific promise, or even if they made a general promise, I might be able to say, well, part of what I paid my $25 a month for, or my $2 a trade for, was for them to protect, not just to let me trade, but to protect my information. And so to the extent I didn't get full benefit of what I paid them for, I have damages. Again, if you only pay $20 a year or $20 a month, your damages are not that big, but if you got 1 million people who had this data breach in a class action setting, Scottrade is still looking at big numbers, right? And so that's the other theory in which, and there have been developments in that area too. I would say that only the risk of harm area shows a clear trend toward letting people bring these suits. In other news, in terms of data breaches, there was a big part of the target settlements were mostly reached in 2017. You may recall, I'm sure most people in the security community probably know a lot more about this than people in the legal community, including me, but the point of access, I guess, for the security breach in Target was through an HVAC contractor that worked for Target. Somehow that let them get into a network that included point-of-sale machines, and then that let them exfiltrate credit card data. Well, Target reached a settlement with 47 different states and the District of Columbia over this breach, which actually happened in 2013. They paid them $18.5 million. That's actually the largest settlement. These attorneys generals often work together on big cases like this, and this was the biggest such settlement. Pretty much, well, it was the biggest settlement ever. There were a couple of states, I think, that didn't participate either for philosophical reasons, like they don't sue when they breach cases. Or one of them may have is an independent action and maybe holding out for a better relief. I can't quite remember who the non-participants are. They were also required to do some fairly generic stuff, like appoint an executive to oversee their program, information security program, have an independent assessment done, and maintain encryption and PI policies. They have to share a fair amount of security information with the attorneys general, which creates kind of an interesting security problem of its own. Because those people may not be best positioned to keep that information confidential and secret, but they nevertheless insisted on seeing it under some kind of peculiar confidentiality arrangement. They promised not to disclose it onto the public under a public record request or anything like that.
Do you know how it was possible that Equifax was able to be backed up as far as people not being able to sue them or have class action suits for what happened, as far as relative to possible future damages?
I'm sorry, how?
After the Equifax situation, I think there was a ruling that people could not take class action suit actions against them.
I don't know about that, but I think, sometimes, I don't think that's right, but I'm not sure. Maybe I missed some legal development that you're familiar with. I mean, if you have an agreement with a company, arguably the company can have you agree in the agreement that you will not participate in class action, that you can only arbitrate a dispute with them. So a lot of companies that you sign up for, credit card companies and things like that, may have those agreements if they're lawful in the states that you contract with them in, that would prevent you from participating in class action. But Equifax is, you and I don't sign a contract with Equifax. So I don't know that there's a way that they can do that. Now, they did try right after the breach. I think this may be what you're talking about. Right after the breach, they basically said, we'll give you a free year of credit monitoring for about a day. They said, we'll give you a free year of credit monitoring before we start charging you $25 a month if you give up your right to participate in class action. But then the regulators came down on them like a ton of bricks. The press came down on them, and they said, oh, no, we didn't really mean that. That was kind of stupid. We don't have to craft that. We take that back. So I think that may be what you're talking about, but I don't think there's actually been a ruling that nobody can bring a class action.
Agreements like Target made with the Attorney General, does that set precedents for other companies that might have to be? Are they now subject to the same rules that Target agreed, like the assessments or the C-level security?
No. Although, what it does tell you if you're a prudent company is that if you have this kind of problem in the future of that magnitude, this is about the kind of thing that they're going to be coming after you and looking for. The Federal Trade Commission, who's by far the biggest purveyor of these consent decree type agreements like Target reached with the attorneys general, they are always very specific about, they not only publish the consent decrees, which have these requirements in them, but they also publish additional guidance for businesses kind of about what they expect. We'll talk a little bit more about the FTC in a minute, but they're not precedential in the legal sense, where a court would say, well, this is what you have to do in that situation because the attorneys general said that. They're law enforcers, they're not courts. So it's not that kind of precedential. It's just predictive of what the attorneys general are going to say your obligations are and were, white and blue. None of these cases are about it's mine and I get to do with it what I want and you did something else with it. They're all about I made a promise and didn't deliver, or I just did something grossly unfair or irresponsible. There's no concept in this country really that you own your birthday or your social security number. Not in the law. I mean, there are many people who feel that way, but not in the law. In Europe, definitely not the case. Much different. We may talk about that a little bit if I get to it. I have a feeling looks like I'm going to not get through my slide deck. And that's fine. This is much more fun than just trudging through the slides. But in Europe, you have a right to be forgotten. You got a right to correct information that's wrong. You have a right to have them make them get rid of information that you really don't need anymore. They have to justify continuing to keep it, things like that. So much different there. The fund didn't end after the Attorney General's. They actually paid more to the banks whose credit cards were misused, and then they also made another settlement with the private litigants, the consumer class action attorneys. So, and then that's on top of all the legal fees and bad press they got. The real harm in most of these data breach cases for these giant companies is reputational injury. A lot more billions of dollars associated with that than what they actually pay out in legal settlements. In the back end.
Do you think that actually exists? Because I mean, Target's reputation for short period, they're doing well now, nobody remembers that now.
Short blip in Target's profitability is a big number. So yes, I really do think it exists. But an interesting question related to what this other gentleman asked about. Can you show that what happens if there's 20 million breaches in a year? Can you any longer say you have an increased risk of future harm? Kind of the same. Does the market become insensitive to repeated data breaches? Does it stop mattering to people? That could happen, but I don't think it's happened yet with effective actors as big as Target. I'm sure there's somebody who's done an economic analysis on it, and you could probably try to figure out what they think the impact of it was. It might have happened in one of the cases. But I don't know. My personal feeling is that it's still the most consequential aspect of the data breach for companies with retail presence, who have a retail name people know.
Because there was an article on the Equifax breach that says, as you said earlier, we're not the customers of Equifax. The financial institutions are their customers, and nobody's complained about the fact that the service they run, their supplier, Equifax, had this problem. So the thinking was, well, Equifax will take a financial hit, fine, but from a business model, it's relevant.
So the thing is, like, we're not the customer for the product.
Well, absolutely. So certainly in this country, that's true, right?
We are for Equifax, we are the product.
Absolutely, yeah. And I say, does anybody know whether entities like Equifax exist in Europe? I mean, are they committed to this? I don't know.
Yeah, there's some UK breaches in there.
Well, right, but they're Americans. I mean, is an entity of that kind really committed to be headquartered? I mean, I guess Equifax has European customers, right? Do they or don't?
Yeah.
I know they have European data, right? But I didn't know if those incidentally reflected.
There are European credit services.
Okay, interesting. Okay, another big settlement, slightly different, is the Uber settlement. This was about, this is an FTC complaint, the Federal Trade Commission brought an action against Uber. I don't know if you remember, but this is basically about Uber employees having kind of open book access to where the drivers went and where the customers went. Uber made a number of mistakes here. They actually had a program at one point in time where they monitored employee access to this data. And after having that policy and program for a while, they basically just stopped paying any attention to it. So that was a big mistake, from the FTC's perspective. You had policy and you just kind of stopped adhering to it. There were also statements made in terms of service about Uber's terms of service about its cybersecurity practice, and the FTC also said. So I guess what they specifically misrepresented was the extent to which they monitored these employees' access. So they still said in their terms of service, we monitor what our employees do with your location data, and in fact they've stopped doing that. They also said they took reasonable steps to secure the data. Turned out they had these backups of location data that were unencrypted on some kind of Amazon web bucket. They also didn't prevent, they had programming, development staff. They gave them one password that basically had, for the whole development staff that had access to everything. So, that was one where the FTC said, we didn't specifically lie to people about that, but, it's just patently unreasonable. You did that. So the FTC has this kind of weird authority. Not really got any specific authority about data security, right? It has the authority to regulate practices that are either unfair or deceptive. So everything they say about data security, they try to classify as either one or the other, unfair or deceptive. Big case last year that we talked about was called Wyndham, about the Wyndham hotel chain, where Wyndham basically attacked their authority to regulate data security at all. Said, come on guys, this is like way too vague. How the heck do we know what we have to do? You can't just say we have to not be unfair and not be deceptive. And the FTC said, well, we've been doing this for 100 years. Why can't we keep them? Ultimately, they settled when the people said their case is still theoretically possible that one day the FTC's authority will be eliminated, which would be a big deal because they're pretty much the 800-pound gorilla of data security enforcement. In terms of statutory law, the kind of interesting developments this year have been really in biometrics. There have been a couple of state statutes adopted protecting biometric information. The original definitions of personal information in the United States and all the data breach statutes were adopted for the most part. Biometric data became a big deal. And so a couple of states have adopted specific rules limiting what you can do with biometrics. Washington State is one. In Washington State, though, only the Attorney General can enforce this law, so you can't have these consumer class actions. Not so in Illinois. In Illinois, individuals can bring these claims. So Illinois is now class action headquarters for biometric lawsuits, and there have been, I think there are 4 suits that I counted that were filed just in September of this year. So they're probably, if you do the math, how long it's been adopted, there's probably a dozen or 2 dozen biometric class actions. In Illinois, what they do is they basically sue these big companies, Facebook and so forth, under the Illinois statute, try to apply that, at least to Illinois residents, and they can get away with it to the broader customer base on the theory that Facebook is subject to Illinois regulation because it does have Illinois customers and sells into Illinois. Texas has a biometrics law, but again, it's like Washington's, it's for the AG only. There's legislation in 3 other states. I expect there'll be a lot more. One of the interesting things about biometrics legislation is, does it apply, and it doesn't make any sense for it to apply in a situation like Apple where they don't keep your thumbprint, right? They keep a hash of your thumbprint. So you can't really reverse engineer it back into your thumbprint. Of course, with facial recognition, sometimes that's not the case, right? Sometimes they just keep your picture, especially like the FBI. They like to see it. Right? So in that case, it's pretty cut and dry. You don't want people willy-nilly throwing pictures around anymore because of what happens. But not so clear when all they have is a hash value why you should care about that. Breach notification laws. New Mexico became the 48th state to adopt a breach notification statute. There are still 2 states, Alabama and South Dakota, where you don't have to report a data breach to your customers or the Attorney General if you have one. Anybody know why South Dakota is on that list? South Dakota is credit card central. South Dakota has the most lenient credit card laws in the world, right? And so every credit card company is headquartered in South Dakota. They still have to do the data breach reporting, but they got customers in all these other states and won't put up with it. But South Dakota will not do anything to repair its marketability and its credit card headquarters. So I don't know what the excuse is for Alabama, other than that it's Alabama. There have been amendments to the laws in other states that shortened the reporting time, added classes of information to what you have to report on. Questionably or not, there have been some movement toward requiring ID theft monitoring. I think with the lawyers in the crowd, defense lawyers in particular are kind of like jaded about this. Like we have to offer it to everybody because everybody kind of expects it, but it really doesn't do any good because of what the gentleman over here said earlier, which is, you get 10 breaches a year, and it doesn't really work all that well, the monitoring, so, what good is it anyway? And they usually charge for it after a while, so it creates another set of problems. But nevertheless, a lot of states are moving toward requiring it. Some of them are moving forward, also requiring, some of these states have in their breach laws that say, well, you don't have to report the breach if there's not a reasonable risk of harm to the people. So this gets at this likelihood of future harm, right? If they could say, well, we don't think anything's really going to happen to these people because of the kind of personal information we let go, even though it's technically a violation of the statute, we don't have to make a report. Well, so some of these states have said, okay, but now you got to do it. You got to put it in writing that what your thought process was about that. So that can be inspected at some later time if we don't agree with you. Okay, so now we're on to developments in the executive branch. Sorry about the orange type, I couldn't resist. The executive order 13800 was one of the bigger developments in terms of the executive branch this year. This is an executive order that Trump promised when he campaigned. It did come to fruition fairly quickly. It's called Strengthening the Cybersecurity of Federal Networks and Critical Infrastructure. It matters a fair amount if you are in the federal government or if you are in a critical infrastructure setting. I tell you what critical infrastructure settings are, but you guys probably know them better than me. There's like 16 of them. I think there might be 17 now if you count the voting machinery. Some of them are pretty obvious, like dams and power plants. And some of them are much less obvious, like voting machinery, for example. This order requires that there would be an assessment conducted of the United States critical infrastructure, requires that we build our national capacity to deal with threats to critical infrastructure and info security threats, both by updating technology and by developing a workforce. Probably that latter is a bigger problem. Good for most of the people in this room, of course. Also requires federal agencies to use the NIST framework if they weren't already, and has some accountability provisions in it as well. Now, the National Infrastructure Council, you may recall, a month or two ago quit, right? They got mad at President Trump for some intemperate comments and they quit. Right before they quit, they told him he was doing a sorry job of implementing this executive order. Opinions are somewhat mixed on that. I think there is some pushback to that. It says, well, basically Obama didn't do a whole lot during his term either. There was talk about it, but we didn't make much progress. And they've actually done some things by the target dates in this order, required certain deliverables by certain times. But that's going to continue to happen. And, the press of events is probably going to cause some interesting developments to arise out of that order. Some interesting changes in both the law and people's understanding of this stuff. Yeah?
The requirement for this framework, is that for all branches of government?
I believe it is, but it may not be. I'm not positive. It's not an area where my practice actually works. So, not DOJ, but right. Maybe somehow linked to the actual where they actually are. Very good. What's that? Yep, somebody in the back. The other lawyer might know the answer.
And this framework is for all of the executive branch, but isn't for the courts or Congress. Although Congress has accepted it through a couple of different statements of Congress. So the CIO of the Congress has said that they're going to follow the predominance.
One interesting feature of most federal laws is they are not for courts or Congress, right? It's quite remarkable how that works. Freedom of Information Act, open meetings, all kinds of things are not for Congress. And the courts, well, nobody pays any attention to it. The NIST has issued some new guidance as well. The draft update to the security and privacy controls for federal information systems and organizations. This matters a fair amount if you are in the federal government. It may also matter if you are a federal contractor. They also, this is like the next generation catalog of controls, I guess they call it. Kind of interesting, and it's really shifted focus to cover a lot more developments in the IoT sector, and it also speaks to industry as well as government. Let's see, I think we're supposed to stop in like 3 minutes, so I think I have plenty more to talk about. I'm just going to look through here. It was developed in 2017, as I said earlier. President Obama, right before he left office, did determine that, although he had decided not to say anything before the election about this problem, that voter data and voter systems were critical infrastructure, and that declaration widens the government's options about what to do in case there's an attack on them. Just recently, the executive branch, the Federal Trade Commission in particular, made clear to toy manufacturers that they could, children could talk to their toys, and they could keep recordings of those commands and instructions that the kids gave to the toys without running afoul of this law called COPPA, which protects personal information of children unless their parents give permission. So that's not really going to count against you. I don't think it had even dawned on internet toy manufacturers that it was likely to count against them, but the Federal Trade Commission has reassured them as long as they don't do anything else with it, except run the toy, they're going to be okay. A lot of developments in surveillance probably doesn't matter to most of us who are in the private sector, except as citizens, right? It doesn't matter to us commercially. Government just added homegrown violent extremists to the list of people that the intelligence agencies are authorized to surveil in the United States. In the international arena, really two big developments, although I've only put one in here, I think, which is that China adopted a cybersecurity law, kind of this interesting hodgepodge of protecting personal information of Chinese citizens, which actually does do, especially from export, but also protecting state interests. There's this long list at the bottom of the slide here of all the things that the Chinese government is concerned about that might get exported from China. Information that's harmful to national politics, territory, military, economy, culture, society, blah, blah, blah. So there are all kinds of reasons they might sanction Chinese nationals for letting information that's negative about the government leave the country. But nevertheless, it's an important issue for American companies doing business here to think about. In terms of looming issues, this is the other issue I said really is a 2017 issue, which is the GDPR, the European Data Protection Regulation, goes into effect next year, 2018. But everybody spent 2017 panicking about getting ready for it. And that's probably occupied almost more than half the bandwidth. So most of the legal conferences I go to is, what do I do to comply with, if I'm subject to it, what do I do to comply with the GDPR? Critical infrastructure concerns are also getting bigger and likely to lead to some legislative change for a lot of attacks on critical infrastructure. A little harder for us to see, but there were a lot that were reported. I'm sorry about the white type that was not a prudent decision in this room, but that actually does itemize several of those attacks. In 2018, the Supreme Court is actually taking up another one of these surveillance cases. This is a different Microsoft case. This is a case that started last year, and I talked about last year, about Microsoft's claim that, well, I have this data on this person over in Ireland. The federal government can't make me give it over because the Irish don't permit that kind of inquiry. And the government's position is, oh, come on, don't be ridiculous. You access it in America every single day. And their position is, yeah, but what if Russia starts asking for information about Americans, because we also can access this information from Russia every single day. So that's a kind of interesting, one of the key features of the case is nobody quite knows whether the fellow who's, I guess it's a man, whose data is being sought is from Ireland or not. The data's in Ireland, but nobody actually, it's not in the court record where he is. So that's kind of a very interesting feature of the case that might complicate the legal analysis. But that case will be figured out in 2018. Also, something you may know on the surveillance front, Section 702, which is the authority that gives them the ability to suck up all this internet traffic, is up for reauthorization. If it doesn't get reauthorized by December of this year, in theory, it comes to an end. So all kinds of interesting results will ensue. It's probably going to get reauthorized. My guess is it's not going to change, but there are efforts being made to change it and challenge it. We won't talk about exactly what it does because we're really out of time. If anybody wants this full set of slides, I'm happy to share them. There are more slides, but these are all about things that I think are really going to come up next year, so they're not really technically part of the year in the meeting. Pass the time. Nobody should feel bad about leaving. I'll stay here to answer questions if anybody has any.